Hey guys, let's go over the firearm evidence in the Richard Allen case. In short, the state says it recovered a round at the crime scene that had been in a handgun that was owned and possessed by Richard Allen at the time of the murders. Let's get into it. Let's look at the gun and the ammo, and then how an expert evaluates that information, and then when the expert heads to the courtroom, how, if it does, it gets in front of the jury and how it's handled in the courtroom. Let's look at those three things. Now, I got right in front of me a SIG 226 that is currently suppressed. And we're going to look at the gun. We're going to look at the ammunition. We won't do it here on this desk. We'll do it. For those who've been there already, I'll welcome you back to the underground bunker. But for those who are new, it'll be your first trip down there. I just brought it up here because any chance I get a reason to bring a suppressed 226 out, why not? And somebody had said, well, maybe he needed to unload the gun, the killer, whether it was Richard Allen or somebody else, in order to fit a suppressor to it so he wouldn't be heard. And if you've not dealt with these kind of tools before, that's a reasonable thing to think about. But it doesn't make any sense because you don't have to unload the firearm to put a suppressor on it or take it off. There are quick attach methods, but generally on a handgun, you're going to thread it on or off. That takes a few moments. I wouldn't want to carry it around like this because it's huge, right? So I could see if you got to the crime scene, you want to use it, maybe you'd stick the suppressor on it and use it. But I don't think that's what happened for a few reasons. One, these are federally regulated, take a lot of time and money to get. And then the second thing is there's no evidence this firearm was fired at the scene. There were no spent shell casings recovered and no bullets recovered, just an unfired round. So I don't think he owned a suppressor or had one, him or anybody else involved in it, or used it in any way that we would know about. So I don't think, and further, you wouldn't have to unload the gun to do it. So we'll look more carefully at this gun, and let's head on down to the bunker and check some of these things out. Hey guys, welcome back to the bunker. We're going to go over some firearm stuff here in the safety of the bunker, including ammunition. I don't use 40 caliber Smith & Wesson anymore, but doesn't mean I don't keep ammo around for it because you never know. So here are some of the different types I have. Full metal jackets, different weights, jacketed hollow points, which are good for shooting things that you want, that are moving, that you want to stop moving. Let's look at one. Here's a good example, 180 grain Smith & Wesson. So it's a bullet that's a little bit larger than a 9mm. And take the glasses off so I can go to it. And here, this is a cartridge. So they said they found an unspent cartridge. That's what this is. So this is a shell casing with the round still in it. This is a jacketed hollow point. If it was full metal jacket, you would just see the copper. And here's the primer that would set it off. Inside is the gunpowder. Boom, there it goes. So it goes into the chamber, and we'll look at this a little more closely. And to get it out of it, you have an extractor that catches on the side of it, and they can pull it out of a chamber. So it's 40 caliber. It's not really any different than any other semi-automatic kind of cartridge, other than the size and some other things about it, but that don't really matter for looking at how the gun works. So let's check that out. Okay, so in a minute we'll get directly into it, because here is a dummy round being held by an extractor, and that's, I think, largely what's at issue in this case. But first, let's take a look at a SIG P226. There are three on this table. One is disassembled, one is here for other reasons I'll talk about, and one is here to actually use. It's an old style gun, still very popular because it works great, it's cool, it's very reliable. How does it work? Well, it's a semi-automatic gun, which means it will reload itself, and it is double action, which means it's in single action mode now. So if you're cocked and you pull the trigger, it will drop the hammer, but you can also pull the trigger and it will do double action. It will cock the gun and then it will also drop the hammer. And that, may or may not be important, because I've seen some people say, well, maybe he was just putting the safety on. Why would you reload the gun in order why would you unload the gun in order to leave? Just put the safety on. Well, I agree you don't need to unload the gun to leave an area, but if you don't have a holster, one reason why you might take a round out of the chamber or unload the gun is these guns typically don't have a safety. They have three controls on it, okay? This is the slide stop, so you can hold the slide back with that if you want, or stops. And you have, this is a takedown lever, so when the slide's back, you rotate this, and that allows you to disassemble the gun. The third thing on it here at the top is the decocker. So you see this gun is cocked now. You decock it. That makes it safer than it was before, because when it's cocked, you have a very light, short trigger pull. And when it's in double action mode, you've got a long, harder trigger pull because you got to overcome the spring and pull the hammer back. But there's no safety on it. There's no way that there's no button on here that if you put it on, this gun, if it has a round in the chamber and the trigger is pulled, won't go off. That's not how this style gun is. There are variants of the 226 like that, but the common one is not like that. I didn't mention the fourth control because it's not really operating the gun, but here it is the mag catch, so you can release the mag out of it if it did have one in it. So those are the controls on it. No safety, a decocker. So if you don't have it in a holster and you're worried that you might catch the trigger on something, then in theory you wouldn't want a round in the chamber. I'm not saying that's why he unloaded the gun or whoever unloaded the gun or racked it. I don't know if they unloaded it. They at least racked it. But I have seen people talk about a safety, and I think that's unlikely in this case to play. Oh my God, a gun without a safety? Well, for example, on Glocks, typically the safety, there is no external safety. The safety is considered this first part of this trigger here. See that? That has to be impressed and then the trigger pressed. That's their quote-unquote safety. Here's a Beretta, which is kind of cool. So it's cocked. It has a safety, and it's also a decocker. Now look, it won't do anything, right? But now, boom, it will go double action mode or single action mode, boom. So it has a safety. Some guns, like this FN, well, it has both. So you can go safety, nothing happens. You can decock it. It has both. It's cool, right? All right, so it takes care of the safety aspect of it. Let's cover one more thing. I heard somebody say that, I don't know why this would work, but somebody said, well, maybe he was racking the gun something to do with a suppressor. Well, no. So for a suppressor to be put on the firearm like this, you need to have something for the suppressor to be mounted on, and that's the barrel, right? So this gun, this is a SIG 226, and it is suppressor ready. It has higher sights so you can see over a suppressor. Threads on the barrel, right? So this other SIG 226, notice it doesn't have any thread sticking out of it. It's not suppressor ready. So here is a SIG 226 9mm, not 40, but that's the only difference, with a fake round in it. And you should be able to see that the round does not go all the way into the chamber, right? Here's the rim of it, and here's where the extractor would be grabbing onto it, because if you want to unload the gun, you got to be able to pull the round out of the chamber, and that's what the extractor does. It extracts. It doesn't take the bullet out of the gun. The ejector will do that. So when you pull the slide back, the bullet will hit the edge of the cartridge will hit this, and that will knock it out of the gun. Extractor, here it is. This is what it would look like in the gun, because this is the slide of the gun. And you can see the little metal part here, the claw, that is the extractor. So that is holding on to this cartridge, right? Enough that it is staying in the gun when I shake it. So it has to overcome a little bit of spring pressure to capture around the edge of that rim. And in the course of doing all these things, it can scratch the brass of the case and create a mark that may or may not be identifiable to a firearm. That's what this whole thing is about, right? Other things happen. Let's take this out of here. If you fire the gun, the firing pin comes out of this little hole here, and that hits the primer. That can leave a distinctive mark. The breech face here may or may not leave a distinctive mark. And the ejector itself can leave an impression on the casing that may or may not be distinctive. So those are all different things aside from the bullet itself, which if a bullet is fired and actually recovered can be compared to what a bullet looks like once it's fired out of the subject weapon, because let's see if I get it. You can probably see the rifling in there, and that the bullet goes down through the barrel, and it's in contact with the barrel so that it will get rotated, and the barrel leaves marks on the bullet because the bullet is a lot softer than the barrel. All right, so the last thing we'll do is I got a bunch of dummy rounds in this magazine, is we'll just show how it operates. So you've got an unloaded firearm. You put your magazine in it, right? And now you got a round in the chamber. She's ready to rock, right? Short trigger pull, this thing could go off if this were real ammo. You can decock it, make it a little safer there, because now you got double action trigger pull to deal with. If you want to unload the gun, you would first take the magazine out, because when you pull this slide back and eject the first round, remember, it loads itself again. It would just load up another round from the magazine. And if you wanted to unload the gun for whatever reason, you would take the magazine out. You see that? It just got ejected out of the gun. So first thing that happened was the case was extracted out of the barrel in the chamber. Comes back, hits the ejector, knocked out of the gun. There's no magazine out there, and it still flew up out of the gun. Let's charge it again. All right, she's ready to rock, right? Now, it's loaded again. So if you wanted to make that noise with the gun, or you weren't sure whether you had chambered a round to start with, you could rack it again. It's just going to cost you one round, right? So let's get it unloaded. She's good to go. That's how SIG 226 works. Let's get out of this bunker. Now let's turn it to, there is some evidence at the scene. What happens? A firearm gets used in a crime, and sometimes there's bullets recovered, sometimes there's casings recovered, sometimes there's rounds recovered, sometimes a firearm is recovered. And sometimes the experts are able to get DNA off of any of these items. Sometimes they're not. A lot of times they're not. Sometimes they're able to get fingerprints off the items. A lot of times they are not. But let's say you want to tie the weapon that was used at the scene of the crime to someone that you suspect, or you want to confirm it because you have other evidence. Then you've got to find some way to match these things there. You got to be able to figure out, well, if this guy had this gun, how do we know this gun was used at that crime? And if you didn't get the DNA and you didn't get the fingerprint, then you're turning to what's called tool mark analysis, which has been used for decades and decades in the court system. If you haven't heard of it before, it's just because you haven't been exposed to it. It's not because it doesn't exist. And it's not because there hasn't been a lot of research on it and crime labs don't have people working on it. Tool mark analysis. Tool mark analysis is the interaction of a comparatively hard metal, let's say the barrel of this weapon, with a softer metal or substance, let's say the bullet that goes through it. So think about a screwdriver, and you slip out of the screw and you slide it across something. It could leave a scraping mark, right? That's a tool mark. And an examiner looking at this thing under a microscope may be able to say, well, this scrape here and this scrape here were made by the same screwdriver, or were not made by screwdriver B, but I think they were made by A, because when they look at the tip of the screwdriver under a lot of magnification, they can see individual characteristics of the edge of each screwdriver and match them up in pattern matching, which is what tool mark analysis ends up doing, and say, well, that's enough for me to say that was A and this was A, and so they were both made by the same screwdriver, or I can't tell, or they weren't made by that, right? And just because you can't see these markings on these things doesn't mean they don't exist. Germs are real, right? And you need a microscope if you want to see one. And individual characteristics on metal parts sometimes you're not able to discern them until they're under heavy magnification. So there is this idea that under a highly magnified situation, that tools become kind of individualized, like a fingerprint. And they'll sometimes even try and compare it to fingerprints in court, the examiners, when they testify, and say that they're relatively individual. They have to be careful about talking about that they're known to be unique throughout the world, but they are individualized, at least in the characteristics they have. And it could be very individual. If you were to gouge your barrel in a certain way that no one else has, because maybe you screwed it up when you're cleaning it or something, you may leave a very distinctive mark that is only in your gun and no other gun because of something you did to it. Who knows? Depends on what the examiner finds when they're looking at this stuff. So the most well-known kind of pattern matching and tool mark analysis is bullet matching, spent projectile matching. It's the CSI kind of stuff. A bullet is recovered out of the victim or at the scene, and you want to compare it to a firearm of the person who you think is the perp. So you take their gun, take it down to the lab, and you fire out some rounds in a control setting, and you compare them to the round or rounds recovered at the scene. This was done last week in the Ortiz serial killer case in Texas. You can watch that firearm examiner testify if you just look it up on YouTube and see what he did for the bullets, the shell casings, etc. At any rate, they'll put these bullets under magnification in a comparative microscope that Indiana also has at their crime lab, and look for patterns and see whether the patterns have a sufficient agreement to say they came from the same source, that these two bullets were fired out of the same gun, or that they're so divergent that they can say it didn't come from that, or maybe due to the state of things, you just can't tell and it's inconclusive. The examiner will say one of those three things, right? And that's what they also do on casings. And that also happened in the Ortiz case, because marks are left on casings in addition to the bullet. The bullet's the one that's most well known, but a casing, because this is a pretty soft metal, can be marked by the magazine, can be marked by the bottom of the breech as the slide goes back and forth, can be marked by the breech face, can be marked by the ejector, can be marked by the firing pin, can be marked by the extractor, can be marked by the chamber wall. Any of those things can mark this casing. So if the examiner examines either the casing or the bullet or whatever, and then reaches a conclusion, an opinion, that this is the same, say. They can say, well, I think the source is the same. Based on my training and experience, I find substantial agreement between enough patterns and markings to say that the source is the same, or to say they aren't the same, or to be inconclusive. That's what's in the probable cause affidavit in the Allen case. And that's the only blurb they have there, which is the subjective opinion of the examiner, says there's sufficient agreement to say that this is the same source. And what did the examiner examine? Well, we don't know exactly. We know there was an unfired round there. And on page 2 of the probable cause affidavit, they mentioned extraction markings. Now, if the round is extracted, that means it was chambered and pulled out. So I'm going from that they're using extractor markings. But there may be other markings too on the round. They don't say for sure. But the extractor would be the most likely to make marks on it. Some of the other things I mentioned could contribute as well. And do they leave marks on it? Well, here's a picture of from a study done many years ago where they were just racking these rounds in and seeing what type of marks were left by extractors from different model guns, so they could see whether, if you had a casing, you could quickly say this came from a Glock, or this came from a Beretta 92, or this came from a SIG 226, whether they were distinctive type of extraction marks without really getting into the fine details, kind of class characteristics. Now, the fingerprint analogy that people like to use, I agree that only goes so far. It only goes so far because, unlike fingerprints, manufacturing methods change and tolerances get better sometimes, and things are made differently than they used to be. So it's possible that the differences between individual parts decreased over time as manufacturing methods get better. It's not always the case, and it's not even necessarily always desirable, depending on how you want to coat the part and things like that. But it's an understandable argument. Do those differences vanish to zero? Is there no way to distinguish between these things? That's one of the criticisms of tool mark analysis generally, not just casing, but bullets. But they continue to do studies, and just a couple of years ago, they did a study where they used 30 barrels, Beretta barrels, that were consecutively run. So that's the nightmare, because they come off the line one right after the other. They should be the closest that there can be, to see whether examiners could tell whether rounds came from this barrel versus that barrel and what the error rate was, because it's also a criticism of the field that you really haven't quantified your error rate, and you're still using subjective criteria, etc. So this was a controlled experiment, so they could know whether they were right or wrong, and they found that the correct answers were given well over 99% of the time, that in terms of not producing a false positive. The field continues to evolve, and they continue to do studies, so this stuff continues to be admitted into court. So let's talk about, in the courtroom, with this round that was found at the scene and matched by an examiner, what happens now? So there are tool mark experts out there. The Indiana State Police Crime Lab has those people on staff. They also exist out in the wild. That's reality. They compare bullets and they compare casings, and that's reality. And these people testify in court and they provide evidence. Again, look at the Ortiz case. If you want to see a recent case where the guy was qualified, testified under the most recent ways to testify as a firearms examiner. So Indiana Rule of Evidence 702 controls for expert witnesses. And you can read it here, but we also don't have to guess at how it would be construed in a case like this, because in State versus Turner, 2011, the Indiana Supreme Court was confronted with the question of whether they would allow, because the trial court did, so were they going to reverse them or not, allow evidence from a firearms examiner expert about casings that were some fired, some unfired, to match them, and there was no gun found, right? No recovery of a firearm. So you didn't have this original tool to even analyze and say, well, I can tell this came from this same gun or not by firing rounds in a controlled way. Instead, they were found at different scenes, and then they were compared to say, well, they must have come through the same gun, and that's how they were connected. And some states, and I think even Texas, said, no, we're not going to let that happen. But Indiana said, we are going to let that happen. And in that case, the court acknowledged some of the criticisms of this, that you don't know the error rate, that the ID is subjective. And the court said, listen, you can deal with all that on cross-exam. You can talk about the level of certainty that the person is saying, and the expert in that case was limited in how certain they said they were. You can talk about the process itself. That goes to the weight of the evidence. It doesn't go to whether I'm going to admit it or not. So it is coming in. Now, you can attack this kind of evidence on 4 fronts. The process itself, some of that we mentioned, that you can't prove the underlying contentions that firearms make individual marks. You are making a subjective ID. So how do you really know how good that is? Your process doesn't tell us how good that is. You don't have a known error rate. These are issues with the process, and they are legitimate issues. You can attack the examiner. Hey, no matter how good or bad the process is, this person just got transferred in from accounting last week. They never shot a gun, and this is the first case they've handled. I don't think they're qualified as an expert. Maybe they fall apart on the stand. So you can attack the examiner, right? Maybe they're blind, and this is a visual examination test. That would be relevant. You can attack how the examiner applies the process. You've got a process, you've got an examiner, but this examiner screwed up. This examiner didn't label the bags right, or this examiner's microscope and the lighting source were wrong. And so there's really, there are a lot of things you can do to attack how the process was applied, chain of custody or whatever. You can also attack the examiner's level of certainty. If they don't say they're very sure about it, then obviously you're going to make a big deal out of that if you're defense. If they say they're too sure about it, it's possible potentially that some courts would exclude that if they're overstating the level of certainty that their testing should give them, right? So it is possible to attack that, and we'll hit that a little bit more detail because the federal government has stepped in on that, at least for their cases. But again, in Indiana, these things have been tried, and the appellate courts have said, look, it's great cross-exam stuff. Do it in cross-exam. We're not going to foreclose this evidence from coming in. Now, there has been skepticism over this evidence, and a report that was issued, I think, in 2016 led some federal courts to start excluding this type of evidence due to some objections to it. And the field responded to that. They've been doing further studies. They've been quantifying things better. They've also been giving out instructions the federal government has on how an examiner should proffer their opinion, so as not to get into too great a realm of certainty for what the testing can offer them. So the Department of Justice has issued uniform language for testimony and reports for the Forensic Firearms Toolmarks Discipline Pattern Matching Examination. And that gives guidance on lots of things to do with it, but part of it is the level of certainty the person should say. And what I'm looking at here is a federal court that allowed the examiner to testify. The casings were fired from the same firearm when all class characteristics are in agreement, and the quality and quantity of corresponding individual characteristics is such that the examiner would not expect to find that same combination of individual characteristics repeated in another source, and has found insufficient disagreement of individual characteristics to conclude they originated from a different source. The court believes, as other courts have also concluded, that the testimony limitations in the DOJ ULTR are reasonable and should govern the testimony issue here accordingly. The court instructs the expert to abide by those limitations and therefore denies the motion to exclude the testimony. Now, that's federal court, so they've kind of adopted the guidelines, at least this court did. Now, those federal guidelines, they're not binding on the Indiana court. And again, I've already cited you the Supreme Court case involved here. But let's see what the examiner is saying so far, as we've seen in the probable cause affidavit. The laboratory remarked, an identification opinion is reached when the evidence exhibits an agreement of class characteristics, kind of the type of gun or whatever, and a sufficient agreement of individual marks, the particular firearm. Sufficient agreement is the term they're using. Sufficient agreement is related to the significant duplication of random, striated, impressed marks as evidenced by the correspondence of a pattern or combination of patterns of surface contours. The interpretation of identification is subjective in nature and based on relevant scientific research and the reporting examiner's training and experience. That's what's in the probable cause affidavit. So that person likely would come to trial, testify to that, and that kind of limited, narrow scope of what the person is saying is going to be allowed into court. And I would think they would show pictures of the microscopic comparisons of the shell casing that they found, as well as the one that they used in the lab to show where they got this pattern from. And that may be very persuasive. It may not be very persuasive. They may have more than one examiner. I don't know if they had it checked by another one, or maybe they call another one. You can expect it to be contested by the defense on any of the four ways that I talked about before, either through cross-exam, okay, that's the easy, cheap way to do it, or through their own expert. They may call their own expert who can say, well, I've looked at this and I do not find sufficient agreement, and here are the reasons why. Look at this is different. That's different. If they were the same extractor, those things wouldn't be different. They may have an expert do that, right? They could have an expert attack the entire field, of course, and we don't know how good this evidence is. It's not as good as having a bullet out of the gun. I agree with that. I don't think it's as good as having a fired casing. Certainly not as good as if you had DNA on the round or DNA anywhere, right? It doesn't really matter if it was on the round or not. If you had Richard Allen or someone else's DNA on the scene in a material way, that would be really good too, right? Although DNA evidence is contested because it can be mishandled, it can be mistested, lots of things like that, then we don't know what this extractor mark looks like. Is it a very faint thing that if you stare at it long enough, you'll see a dolphin? Or is there something about it that makes it look really unique? So we can't say the weight of this evidence. But I hope this video has helped you at least see a little bit about how the gun works, the process involved in gathering this evidence and tool mark analysis, what it is. It's not been ruled as junk science by courts generally in federal court or state courts. It is admissible. It doesn't mean it's conclusive, okay? That's not what I'm saying. But I'm saying that it is not novel, and it's not used, and it's not worth anything. It's too hard to judge at this point. So again, I hope at the end of this, they find out for sure who did this. And if it's Richard Allen, I hope he's convicted and he pays for this. If it isn't him, I hope he's not convicted. If it isn't him, I'm sorry he's going through this. Do they have the right guy or not? I can't say that. We'll just have to wait until things become public and there is a trial, and we'll let the jury look at it and the jury decide. Thanks, bye.